Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Now, for those of you who routinely geek out on the channel, one, thank you very much. Number two, occasionally I will put a little disclaimer at the front of a video that I think is really going to get your blood boiling. This is one of them. So, if you need to hit pause, go pour yourself a little bourbon, do some breathing exercises, whatever it takes to get through this, because yes, you are going to be pretty ticked off when you hear what I have to talk about today. Now, can you imagine, in the year 2024, a state Supreme Court coming to the conclusion that neither the Second Amendment of the federal Constitution or the equivalent in that state constitution provides an individual with the right to keep and bear arms? Can you believe that? Well, guess what? That has actually happened, and it's happened in February of 2024. Where? It's out in the state of Hawaii. It's the Hawaii State Supreme Court. It is absolutely the most disgusting ruling you will ever read, but you need to be worried about this because, listen, this stuff does have a tendency to spread like cancer. So today, let's get everybody educated and let's talk about the worst Second Amendment ruling you will ever read. Okay, the case we're talking about today is the case of Hawaii v. Wilson. It was argued before the Hawaii State Supreme Court. They have issued absolutely the greatest abomination of inalienable right ruling in the history of American jurisprudence. One of the things that the state of Hawaii relied upon in coming to this amazing conclusion is that, well, when the state of Hawaii got around to adopting its state constitution, since they were the 50th state, our understanding at that time of what our Second Amendment rights were considerably different than what we believe it to be today or what we believed it to be back in the late 1700s. And so that along with the Aloha spirit, I'm not joking, it's cited in this memorandum, allows them to come to this ruling that the Second Amendment, both of the United States Constitution as well as the Hawaii State Constitution, does not provide an individual with the right to keep and bear arms. Now, I'm going to try to get through this opinion really fast so we don't have a super long video and so many of you don't stroke out just listening to everything. But this is not only one of the most poorly reasoned opinions, this opinion is full of sarcasm, it's full of cheap shots directed at the United States Supreme Court. This is for a group of individuals who routinely scream about the rule of law. This is a state Supreme Court basically thumbing their nose at the rule of law. Article 1, Section 17 of the Hawaii Constitution mirrors the Second Amendment to the United States Constitution. We read those words differently than the current United States Supreme Court. We hold that in Hawaii, there is no state constitutional right to carry a firearm in public. I'm not making this up. We're going to link everything up down below, so if you believe that I'm just completely pulling an early April Fool's Day joke on you, you will see this is real. The court went on to say, Bruin snubs federal principles. Still, the United States Supreme Court does not strip states of all sovereignty to pass traditional police power laws designed to protect people. Now, the court went on to say that, well, do we interpret the federal constitution or the state constitution first? They decided, well, we're going to interpret the state constitution. It doesn't really matter. They came to the same conclusion no matter what. But the court did rule, we hold that the text and purpose of the Hawaii Constitution and Hawaii's historical tradition of firearm regulation do not support a constitutional right to carry a deadly weapon in public. Now, the defendant in this case, Mr. Wilson, actually filed challenges to three separate Hawaii laws. One was carrying in a prohibited place, the other one was having ammunition in a prohibited place, and the third one was carrying without obtaining a license. The court only allowed him to actually challenge under two of these things. The third statute dealing with the license, they said, hey, you never even bothered to apply for a license, so you don't even have standing to do that. My understanding is even had he applied for a license, they don't grant licenses in Hawaii. It's one of the most superfluous license application regimes in the country. But in getting back to the fact that, well, we got to decide, do we interpret Hawaii Constitution first, the United States Constitution? The court did rule, thus we interpret the Hawaii Constitution first and may not get to the United States Constitution. Yeah, the problem is they make that statement on page 12, and it takes 53 pages to absolutely screw Mr. Wilson and every resident in the state of Hawaii, for that matter, of their inalienable rights. So we all know where this is going. Now, if you want to know the disdain that the Hawaii State Supreme Court currently has for the United States Supreme Court, consider this. Rather, this court frequently walks another way. Long ago, the Hawaii Supreme Court announced that the opinion of the United States Supreme Court is merely another source of authority, admittedly to be afforded respectful consideration, but which we are free to accept or reject in establishing the outer limits of protection afforded by the Hawaii Constitution. To give you an idea of how the court even views the right to carry any sort of a firearm or other weapon outside of the home, consider this one little paragraph here. Wilson argues that the statutes violate his putative right to keep and bear arms under Article 1, Section 17 of the Hawaii Constitution and the Second Amendment's brand new right to bear arms in public for self-defense. Okay, did you catch that? The Second Amendment's brand new right to carry arms in public for self-defense. That is how this court sees the Second Amendment. So, if you really want to know how bad things can get, go back to the Heller opinion and then read the dissenting opinion. Because what the dissenting opinion basically in Heller says in a nutshell is that the Second Amendment is reserved only for those who actually serve in the militia. That service in a militia is a condition precedent to actually having that individual right. And so it's not actually an individual right. Instead, it is a collective right. Now, that was the minority opinion in District of Columbia v. Heller, but that minority opinion is cited over and over and over in this particular opinion because apparently the Hawaii Supreme Court, unlike any other state in the Union, has this amazing ability to kind of take Supreme Court precedents as advisory in nature. As they put it, because the text of Article 1, Section 17, its purpose and Hawaii's historical tradition of weapons regulation support a collective militia meaning, we hold that the Hawaii Constitution does not afford a right to carry firearms in public places for self-defense. The court actually believed that the term bearing arms or to bear arms only has a military application, that those words only meant bearing arms for purposes of military service. As the court put it, non-military uses of bear arms in reference to hunting or personal self-defense are not just rare, they are almost non-existent. So with that in mind, they come to the conclusion that both the Second Amendment of the United States Constitution as well as Article 1, Section 17 of the Hawaii State Constitution do not provide any individual rights. I'm not joking. This is how the court ruled. Judges interpret words as part of the job, but judges are not language and speech specialists. Before Bruin, linguists informed the Supreme Court about their research. Corpus linguistic researchers have unearthed a wealth of new evidence over the past decade showing that the phrase keep and bear arms overwhelmingly had a collective militaristic meaning at the founding. I want you all to pay very careful attention to that last quote because you are going to see that again and again and again. Watch the Ninth Circuit. Watch anything in the Seventh Circuit. Watch anything out of the state of Illinois, state of California, state of Washington. That is the exact reasoning you're going to begin to see on a lot of other cases in which the court wants to uphold civilian disarmament. The court apparently believes that because it didn't come right out and say it, that right does not exist. Don't believe me? This is what they said. We believe that if Article 1, Section 17 meant to provide an individual right to carry deadly weapons in public for self-defense, then it would say so. Ultimately, the court believes, we conclude that the authors and ratifiers of the Hawaii Constitution imagined a collective right. So then you sit there and go, okay, great, your state constitution doesn't provide that, but what about the federal constitution? Because as we know, there is actually case law directly on point that says, yes, that's exactly what it does. Well, au contraire, you see, because the state of Hawaii has this unique ability where they can accept or not accept Supreme Court precedent, according to the court here. And then, of course, because the Second Amendment also uses the language to keep and bear arms that only had a militaristic application. As the court ruled, like Article 1, Section 17, the Second Amendment's original purpose protects a state's right to have a militia. The framers included the right to keep and bear arms in the federal Constitution in response to their fear that the government might disarm the militia, not restrict the common law right of self-defense. And of course, we get back to the old cop-out, well, the founding fathers would have never been able to consider modern weaponry. That is true. They also wouldn't have been able to contemplate modern forms of communication, yet the First Amendment covers that. They would have never been able to contemplate all forms of modern religion, yet the First Amendment contemplates that. They would have never been able to contemplate electronic surveillance, except the Fourth Amendment still covers that. And so that is one of the most hollow cop-out arguments that anyone could ever advance in favor of civilian disarmament. But you sit there and you go, yes, but the Bruin test is rooted in history. And history shows us what we as a society have accepted as reasonable restrictions on our otherwise inalienable rights, correct? Wrong, not according to the state of Hawaii Supreme Court, because they ruled history is prone to misuse. In the Second Amendment cases, the court distorts and cherry picks historical evidence. It shrinks, alters, and discards historical facts that don't fit. Bruin unravels durable law. No longer are there levels of scrutiny and public safety balancing tests long used by our nation's courts to evaluate firearms law. Instead, the court ad-libs a history-only standard. Yes, that is exactly what the Bruin court said, but this court is essentially thumbing their nose at it saying, no, they're wrong, we're not going to do it. The Supreme Court makes state and federal courts use a fuzzy historical and traditions test to evaluate laws designed to promote public safety. It scraps the traditional techniques used by federal and state courts to review laws passed by the people to protect people. And by turning the test into history and nothing else, it dismantles workable methods to interpret firearms law, all to advance a chosen interpretive modality, or to actually advance the Second Amendment rights that our founding fathers actually established for us. You can see what happens when a court is completely, and I do mean completely, result-driven here. And if you really want to know just how disingenuous this court is and how poorly reasoned this opinion is, I'm going to share with you a quote, and I want you to take a look at what the citation is to the source of the information. As the world turns, it makes no sense for contemporary society to pledge allegiance to the founding era's culture, realities, laws, and understanding of the Constitution. The thing about the old days, they the old days. Quote, The Wire, Homerooms, HBO television broadcast, September 24, 2006. I mentioned earlier that the spirit of aloha also apparently allows the Hawaii State Supreme Court to ignore the United States Supreme Court. Think I was making it up? Check this out. The spirit of aloha clashes with a federally mandated lifestyle that lets citizens walk around with deadly weapons during day-to-day activities. The history of the Hawaiian Islands does not include a society where armed people move about the community to possibly combat the deadly aims of others. Okay, like I said, there are bad rulings, there are terrible rulings, there are god-awful rulings, and there is this one. This is absolutely the worst ruling I have ever seen since I started geeking out on Second Amendment cases. The case, once again, is Hawaii v. Wilson. We will go ahead and link it up down below so that you can geek out on this abomination of an opinion for yourself. What this means for Hawaii moving forward is not good, okay? There is already a big civilian disarmament regime in place. They are going to run roughshod with this opinion. They are going to start squelching out the inalienable rights of every single citizen. And Hawaii v. Wilson may have just bought its fast ticket to the United States Supreme Court. Listen, if you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, which in Hawaii is absolutely nothing now, you should know how to get a hold of Washington Gun Law. If you don't, that's okay. That information, it's down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.